Hi everybody, and welcome to week 2 of the course and your week 2 lecture video. And this week we're going to be covering reproductive rights, the right to privacy, which also includes the rights of the LGBTQ population, and the rights of women. So that's a whole bunch to cover in 1 week. So let's keep moving. And by the way, as I mentioned last week, we're taking topics out of order. Instead of going, First Amendment, Second Amendment, Third Amendment, Fourth Amendment, I figured it made more sense to go in the order of things that are in the headlines. So we'll kind of be taking that approach instead. So this is our agenda for this session. We'll take care of some housekeeping matters first. Then we'll look at an overview of the right to privacy. So it's kind of a unique concept in constitutional law. Then we'll look at reproductive rights cases. And speaking of reproductive rights, why weren't they codified? In other words, why didn't Congress make some kind of law and have it written into the U.S. Code? We'll talk about Biden's executive order a little bit. Then we'll talk about the rights of the LGBTQ community, along with other important rights for women, and wrap up with our takeaways and our to-do list for next week. All right, so for housekeeping matters, you'll notice when you open the folder for week 2 and you look at your little list of things that you should do this week, I remind you to make sure that you know how to access the textbook. It can be a little bit tricky at first, learning how to navigate a large PDF doc, and you'll see there are some instructions there about downloading it to your device, so that way you can use all the navigation features, and there's even a little link when you click on free textbook that gives you a tutorial about how to use those navigation features. I also remind people how important it is to watch the videos, because some of the things I'll ask you questions on are things that maybe I didn't assign any readings on, because I can't, assign you 300 pages of reading a week. I mean, I could, but that wouldn't make much sense. So some things are just covered and summarized in video lecture, and it'll actually save you a ton of time reading and a lot of confusion having somebody synthesize things for you who's been studying this for a while. I also show you how to access the OIA's site, which is very useful for a wide variety of reasons that you will discover over the semester. And you can also look over the handout that tells you how to skim and also gives you tips and pointers about the types of questions that professors might ask you. And I also remind you to review the results of past tests, so then you know going forward what you got right and what you got wrong, because one idea builds on the next. Basically, you just click on My Grades, and then you see your actual test score, and then you click on the actual test score itself, and you can see what you got right, what you got wrong. You can see my comments and things like that. I think on the student's point of view, you have to actually click on that little blue bubble you'll see to review my comments. But in any case, that's something that's really important to do. So you're going forward knowing what you got right and what you got wrong in the past week. All right, so turning to the right to privacy, it's somewhat of a unique and complicated concept in constitutional law. So I want to do away with some myths. The number one myth that a lot of people have, especially if they've never studied constitutional law in detail, is they think the right to privacy, which will be shortened to RTP, they think that it only pertains to the rights of citizens to be free from unreasonable searches and seizures. And they think about it in a pure criminal law context, or in the context of, the government has to stay out of my business. And it does mean that. But it doesn't only mean that. It also has to do with this very specific area of constitutional law that has to do with reproductive rights, the right to terminate a pregnancy, the right to get birth control, and to a certain extent, the rights of the LGBTQ community. The Supreme Court, as we'll see, doesn't really know what part of the Constitution it wants to focus on when it's trying to protect the rights of gay people. We'll see that. But the number 2 myth is that it only comes from one place in the Constitution. It comes from many places, which I'll expand upon in a minute. But just to let you know what I mean by that, if we were examining a case that had to do with me being able to freely express my religion, like say I was a public school teacher and I wanted to wear a cross around my neck to school as jewelry, and since it was a public school, my principal told me I couldn't do that. Well, we would only be looking at the First Amendment and the parts of the First Amendment that have to do with free expression of religion. And by the way, there's never been a case like that. And if there were, I'm 90% sure I could say that the Supreme Court would back me up and allow me to wear my cross necklace. But in any case, you don't just look to one place in the Constitution. We'll get to the actual language that shows you that you look to a bunch of different places in the Constitution. Which brings us to the number 3 myth. Some people think that everyone agrees that it is found in the Constitution, and by it, I mean the right to privacy. And that's not true. There's an argument now, since the recent court decision that overturned Roe versus Wade. There was a recent case decided by the Supreme Court called Dobbs versus Jackson that overruled the Roe versus Wade case. And not only did the language of that case say that there isn't a constitutional right to terminate a pregnancy, but it also had language that argued that the right to privacy, as it was previously outlined by the Supreme Court, it doesn't exist. So there's an argument among constitutional scholars about whether or not the right to privacy exists, and it really depends on your political philosophy and your philosophy about how you interpret Supreme Court cases. As a very general statement, if you're a judicial activist, you would agree that there is a right to privacy in the Constitution and that the Dobbs versus Jackson case was wrong and that Roe versus Wade should have never been overturned. And people who are judicial activists say that you shouldn't just look at the literal language of the Constitution, you should look at the overall spirit and meaning, and that you can read between the lines to pull out and protect rights that were intended to be there. Somebody who exercises judicial restraint, somebody who has that philosophy, another way of putting it is somebody who's a traditionalist or a literalist, and that's the majority of our Supreme Court justices right now. Those folks would think that the Dobbs versus Jackson case was a good decision, that Roe versus Wade was something that should have been overturned, and that the right to privacy doesn't literally exist in the Constitution, so that there shouldn't be Supreme Court cases that spell it out. And they would agree that the matter should be left up to the states, which some would argue is extremely problematic for a number of reasons that we'll get into in just a minute. All right, so getting to our first important case that has to do with the right to privacy and reproductive rights is a 1965 case called Griswold versus Connecticut. And this case actually had to do with birth control, not the right to terminate a pregnancy, but it laid the foundation for future cases. And before I get into it, a helpful tip for when you go to read these Supreme Court cases, and I urge you to look at the excerpts of the cases that are in your digital textbook. Those pieces of the court cases that appear in your textbook might appear long, but they're actually not the entire Supreme Court cases, because actual Supreme Court cases are like 30 to 100 pages long, single space, double-sided, 8-point font. I mean, they're really ridiculous. So the textbook contains just the main chunk of the case, and then if you're finding that really inaccessible to your learning, you can always look up the case on oyas.org. But in either case, no matter how you access reading the case, whether it's a summary, the whole thing, an excerpt, one common point of confusion is that people kind of read the beginning and stop, and they're only reading what the lower courts decided, and they never get to the part where they talk about what the Supreme Court of the United States said. So people get done with reading, which is only halfway reading, and they don't understand what the rule of law is because they didn't read about what the Supreme Court said. They only reviewed what a lower court said. So that's just a little pointer or tip that you want to distinguish between what lower court said, which isn't the final word, and what the Supreme Court of the United States said, which is the final word. And next week, I will have a handout that gets into more detail about how to read a Supreme Court case, but I didn't want to throw too much at you at once. So you'll see the case of Griswold versus Connecticut involved a Connecticut woman who was married who wanted to get prescribed birth control from her own physician, but there was a law in Connecticut that prohibited this. And so the woman and her attorneys appealed this up to the Supreme Court of the United States and argued that there was this right to privacy that was inherent in the Constitution that made it so that this law should be struck down. And the Supreme Court of the United States back in 1965 agreed. And they further explained that the right to privacy wasn't found in any one specific amendment, but that it emanated from the penumbras of the Bill of Rights. In other words, it's shown forth through the main meaning and the spirit of the Bill of Rights, and that they were looking at due process, which is in the 14th Amendment. That means fair treatment in court. They also pointed out marital rights. And when they were writing about which specific amendments they were looking at when they were reading between the lines of the Bill of Rights, they looked at the First, Third, Fourth, and Ninth Amendments, and that they created the right to privacy in marital relations. So this was limited in scope at the time for married couples being prescribed birth control, actually a married woman being prescribed birth control by her physician, and a law that was intended to strike it down, but it was the foundation for future very important cases. So now we move on to Roe versus Wade, which was decided in 1973, and this is the abortion rights case that was overruled by the Dobbs versus Jackson case that made all the headlines a couple weeks ago. So to summarize a whole bunch of facts, there was a woman who lived in Texas that was seeking to obtain an abortion, and the state of Texas had a law at the time that made abortion illegal. And like many Supreme Court cases, she wasn't the only one filing in the Roe versus Wade case. The main plaintiff in the case, and the plaintiff is the person filing a lawsuit or a case, the main plaintiff in the case was given the name Jane Roe to protect her privacy. And, excuse me for a minute there, I got interrupted. And there were other women along with Miss Roe who joined this in a what's called a companion case. So it's kind of strange that by the time this whole case was said and done, the baby that was the main subject of this case had already been born. But the Supreme Court decided to hear it anyway, even though usually the mootness doctrine would have prohibited them from hearing the case. Remember, the mootness doctrine says that if there's no more case or controversy alive, then the court will not hear the case. But there's an exception if the issue is bound to keep repeating itself. So anyway, the focus of the lawsuit was whether or not the right to privacy protected the right of a woman to terminate her pregnancy. And the Supreme Court of the United States found that, yes, it did. Back in 1973, they decided that the right to privacy protected the right of a woman to terminate her pregnancy. There were some limitations on that right. They quoted a lot of the same language. Sorry about that interruption. But the court did quote a lot of the language that was in the Griswold versus Connecticut case, the language about the right to privacy and where it derives from, and penumbras and all that unique language. And they also pointed to the due process clause of the 14th Amendment, which, if you remember from reviewing the Constitution, that pertains to fair treatment in court. They did not institute any marital limitations, such as the person had to be married to exert this right, or that it was only for birth control. A lot of people were worried about that because they thought the Griswold case would only institute a right to privacy for married people and for birth control. But the Supreme Court did not say anything about that the woman in question had to have a certain marital status. But they did issue some limitations. And the limitations had to do with the trimester framework. So let's look at the trimester framework in just a minute. All right, so what is this trimester framework all about? Well, basically, the court in Roe versus Wade said that you can have some restrictions on abortion depending upon what trimester of pregnancy you're talking about. So in other words, if a woman is up to 12 weeks pregnant and she's in her first trimester, the state in question can't regulate the abortion decision that it's between the pregnant woman and her attending physician. So it's between them, and states can't make any laws restricting abortion up to 12 weeks. When we're talking about the second trimester, which is when somebody's 12 to 24 weeks pregnant, the state can impose regulations on abortion that are reasonably related to maternal health. And if you're thinking to yourself, that language is kind of vague and open to interpretation, and that could cause problems, you're right. You'll see how that can cause problems. The third trimester is when somebody's 24 to 40 weeks pregnant. Yes, a lot of people will say, wait a minute, 9 times 4 is 36. Isn't a woman only pregnant for 36 weeks? Well, if anybody in this class has had a baby like I have, you learn to your surprise that it's lunar months. They measure pregnancy in, and you're pregnant for 40 weeks. But in any case, in the third trimester, once you're past 24 weeks, which at that time was the point of viability, because think about medical technology back in 1973, there's no way that a baby could survive outside the womb before 24 weeks. Even back in 1973, it was, iffy if a fetus could survive outside the womb at 24 weeks. So in any case, back in 1973, they said once the fetus reaches the point of viability, A state can regulate abortions, prohibit them entirely, but there has to be exceptions for cases when abortion is necessary to save the life or health of the mother. And they did not mandate an exception for cases of rape or incest. So that's what we had as our trimester framework and as the rule of law for a long, long time, because the next major abortion decision wasn't made until 1992 with Planned Parenthood versus Casey. And what happened over the years is because that trimester framework was worded in kind of a broad way and open into interpretation, depending upon what state you lived in, the state legislature would try to make it harder to get an abortion. So, for example, here in Massachusetts, which is a liberal state, you did not have state legislatures for the most part. Like in the Northeast, you didn't have states trying to make it harder to get an abortion, but in states that are historically conservative, so-called red states, right? Red is the color for conservatives, blue is the color for liberals. So in traditional red states, you did have laws like that were slowly coming into place. So a new Supreme Court case on the issue was bound to come up. And also because medical technology kind of made the trimester framework a little bit less useful. Nowadays, sometimes you have babies who can survive outside the womb at 20 weeks. They might have medical issues, but you can, in some cases, have a baby survive outside the womb at 20 weeks. We weren't quite there in 1992 with medical technology, but still, the trimester framework became limited. So the specific questions that came before the Supreme Court were whether or not certain restrictions were constitutional or not. And here's the restrictions that were in question. Can a state require a woman who wants an abortion to obtain informed consent? In some states, that informed consent involved, reading and signing a paper that informs them of the medical risks to the woman. In some states, they would add on exceptions that had information about, this is what the fetus looks like at 10 weeks. This is what the fetus looks like at 11 weeks, so on and so forth. In some states, they would actually do an ultrasound as part of the informed consent. And somehow that was worked into the informed consent to let the woman know about, the stage of pregnancy and her anatomy and the risks and so on and so forth. Another regulation that was in question was whether they can make somebody wait 24 hours as sort of like a cooling off period to think about whether they wanted the procedure or not. Another one was whether or not, if the woman was married, that she had to notify her husband. Some people thought one of the regulations that was in question was whether or not a woman had to get signed permission. That wasn't specifically part of this case, although some women were dealing with states that were trying to do that. Another regulation that was in question was whether or not a minor had to get parental permission. And in most states that had these laws where a minor had to get parental permission, there was a judicial bypass option. And a judicial bypass option involves having the child, the minor, sign a piece of paper with the court saying basically they wanted to avoid getting permission from their parents, and can they get permission from a judge instead. And so I was actually part of this process in another state way back in the 90s in New Hampshire, where I went with a minor up in front of a judge where they get permission from the judge to get the procedure. And it's just a formality. The judge always signs it. They just ask for a piece of paperwork from the doctor saying it's safe for this particular patient, and then they sign off on it. So that was another regulation that was being analyzed by the Supreme Court, whether this parental consent requirement usually included a judicial bypass, whether that was allowed. And then they also were looking at the trimester framework again. So in the end, what the Supreme Court ruled was yes to all these regulations, except they said you can't make a woman notify her spouse or get permission from her spouse. And also, if a state is going to have a regulation that someone under 18 needs to get parental permission, you have to have this judicial bypass option. So, in other words, it was okay to make women sign informed consent paperwork. They didn't outlaw any ultrasound procedures. They said it was okay to make a woman wait 24 hours. And again, for minors to have to get parental consent as long as the judicial bypass option was available. And the Supreme Court also acknowledged advances in medical technology, not in a real specific way with any medical terminology, but they said instead of looking at the trimester framework, we're not going to overrule Roe versus Wade, but what we are going to say is in the future, when we look at abortion laws that are trying to restrict abortion, we're going to look at whether or not they're an undue burden on the woman's right to privacy, the right to terminate her pregnancy, and whether or not the fetus is viable. So in other words, we're going to look at these two things, the undue burden, which again is open to interpretation, and whether or not the fetus is viable, which at that time was around 22 to 24 weeks, but now in 2022 is closer to 20 weeks. So if we're talking about abortion cases, now we have to get up to present times, Dobbs v. Jackson, and the 2022 case that was decided very recently. And to give you some political and historical context, there has been, a lot of history of people with different political philosophies and people with different philosophies about how to interpret the Constitution, arguing since before the 1960s about whether or not we should be looking at the Constitution when we're talking about the woman's right to terminate her pregnancy, or whether or not we should be looking at just drafting regular laws that have nothing to do with the Constitution. Just like there's been a battle for as long as this country has been around, whether or not it's the role of Supreme Court justices just to interpret the Constitution and be like an umpire and call balls and strikes, right? Which that's language I'm borrowing from our present Chief Justice John Roberts. He's somebody who's a literalist, a traditionalist, somebody who certainly is not a judicial activist. He's the opposite. He's a literalist, and he says that we shouldn't read things into the Constitution that aren't there. And on the other side of that historical argument are people who say we should be judicial activists, and if there is a civil right or civil liberty that's at risk, we should really look with a microscope to see and analyze whether or not that exists or was intended in the Constitution and draw from that to protect civil rights and civil liberties. So, for example, think back to what you learned in history class, how in 1954, the Brown versus Board of Education case said that the schools had to be integrated and that separate was not equal, and that the schools had to be integrated, and that segregation in the schools was unconstitutional. They pointed to the Equal Protection Clause of the 14th Amendment, but it doesn't literally say in the Constitution that schools had to be integrated, or else African Americans would be harmed and their civil rights and liberties would be violated. Actually, if you look at the plain language of the Constitution, it condoned slavery and only counted our fellow human beings as 3/4 of people. That was later rectified. However, that's the argument that could be made against the extreme literalist approach. So, the law that was being analyzed in Dobbs versus Jackson was a Mississippi law that just outright banned abortions after 15 weeks, and whether or not this law violated the Constitution. And again, to give it context, people were really afraid when the Supreme Court was deciding this case that Roe versus Wade and the Casey case were going to be overturned, because we now have 6 conservative justices on the courts, and the people who were concerned about this issue ended up having their fears come true. It was a 6-3 decision, with the 6 conservative justices being the majority, deciding that, yes, Roe versus Wade should be overturned. So the court essentially said that, hey, abortions are not banned. It's just this specific right you're talking about. It doesn't come from the Constitution. So what you should do, you, meaning collectively you, citizens of the United States and lawmakers, what you should do is leave it up to the states, and it's a state-by-state decision. We're not really seeing this right to privacy and penumbra stuff in the Constitution, and Roe versus Wade is overturned. Of course, the 3 liberal justices, were not in agreement with this, and when you look at the entire decision, you can see that the liberal justices, at least one of them, wrote a really long, scathing dissent. And you can also see, as a counterpart to that, one of the conservative justices wrote a concurring opinion. And a concurring opinion means you agree with a majority decision, but for different reasons, or you want to flesh out some more constitutional analysis. We'll be reviewing some more of these terms next week. But Justice Clarence Thomas, in his dissent, wrote some language that was concerning, because he said, well, now let's look at some other cases that partially relied on the right to privacy, which are making some people fearful for the future. And we'll review that in upcoming weeks. So that's the case we have right now. And there are some really significant effects and consequences. On the one hand, people would say, what's the problem with leaving it up to the states? And there are some issues that somebody could bring up in response to such a statement. One could be, if I'm a woman in Texas, why should I have fewer rights than a woman in Massachusetts? Additionally, what if I'm somebody who is in a very bad economic situation in a large state like Texas? If you're smack dab in the middle of Texas, traveling out of state is a very expensive and lengthy endeavor. And instead of being able to go to my local clinic and have an abortion procedure, I'm going to have to get time off of work, pay for travel, pay for out-of-pocket medical costs. So in reality, I might have the right to go to another state, but the real reality is that it's just not going to happen, most likely. And when it comes to some of the issues with enforcing these laws, there are certain medications that women who are of childbearing age are getting denied, because if they were pregnant, it would terminate that pregnancy. There's a couple of common strong medications for arthritis that women are having trouble getting. in these red states where abortion is outlawed. It also affects a physician's agency to make good decisions for his client. There was recently a physician in Ohio who had a 10-year-old patient who was a rape victim who wanted to get the procedure, the abortion procedure. This particular minor was beyond the number of weeks pregnant allowed in that state to get an abortion. So this physician referred her to a colleague out of state. And now this happened in Idaho, where this poor rape victim had to travel from. And so now certain officials in Idaho are trying to discipline the Idaho physician who coordinated all the care for this person. So some people think that physicians are just going to do the procedure for women who really need it. They're not, because they could lose their licenses. And even if they refer somebody out of state, they can still face disciplinary action. And the other consequence is it's one of the few times we've sort of gone back in time. Supreme Court decisions, when they've overruled prior decisions, it's usually been because they're saying things like, okay, segregation was wrong, slavery was wrong, discrimination against women was wrong. It's not them taking a step back and taking away rights. So a lot of the effects and consequences I'm talking about are political effects and consequences. Whether you think they're positive or negative will probably depend upon your political point of view on a woman's right to choose. But there are actual medical consequences for people on common arthritis medications, and also consequences for people who are poor, who are rape victims, so on and so forth. So it begs the question, why not codify this right? And by codify, I mean, why don't we now, or why didn't we before, write this into law instead of relying on a Supreme Court case? Well, that's a good question. Somebody asked Obama that, and somebody asked previous Democratic presidents the same question. And for the most part, to summarize a lot of news articles, they kind of said, well, we probably should have, but we never thought Roe versus Wade would get overturned. Some people are also concerned about trends in other countries. So as far as next steps and what's being done now, Biden has issued an executive order, and you can click on the link if you're interested in what it says. The Cliff Notes version of it is basically that Biden is saying that physicians nationwide are empowered with providing women with emergency medical care, right? Because another big concern is an ectopic pregnancy. And an ectopic pregnancy is when instead of the zygote, which becomes a fetus, instead of the fertilized egg implanting in your uterus like it does the incredible majority of the time, something goes haywire and it implants inside your fallopian tube instead. And this is really medically dangerous. I saw what happened to a loved one when she had an ectopic pregnancy, and she doubled over in pain, screaming, and fainted, and had to be taken to the emergency room. So what usually happens is somebody comes in with complaints of severe abdominal pain, and because of the symptoms, emergency medical personnel at the hospital, if you have a uterus and you aren't in menopause, they're going to, and you're over the age of puberty, they have you pee on a stick, they would be able to see that you're pregnant. They would do an ultrasound, they'd pick up the ectopic pregnancy right away. It's really easy to diagnose, and they would terminate it, and they would hopefully be able to save that fallopian tube, because that fallopian tube is what connects the uterus to the ovary and what enables somebody to get pregnant. So they'd want to preserve the woman's fertility. So what Biden did is he made it clear that physicians can treat an ectopic pregnancy, because if they don't, somebody can die if you don't terminate the ectopic pregnancy. So he made clear in this executive order any other type of emergency medical care can be provided and that you won't face any penalties. He didn't go further and try to overrule Dobbs v. Jackson in an executive order, because that would be a waste of time, because some group would just bring it up before the Supreme Court, and it would get stricken down. The power of the Supreme Court to strike down acts of Congress that are unconstitutional is called judicial review, and that also applies to miscellaneous state regulations, executive orders, so on and so forth. So the next steps are for Congress to get off its behinds and actually codify this, make it into a law. Federal laws are called codes. They're part of the U.S. codes. State laws are called statutes. So they have been doing their homework. Just a couple days ago, as I'm sitting here on Sunday morning recording this, the House of Representatives passed a bill. And if you know anything about American politics right now, that's the easy part. As far as the House of Representatives and the political makeup of people, that's an easy win, getting this abortion rights law through the House of Representatives. Getting it through the Senate is another battle. We only have a slim majority in the Senate, and you need more than a slim majority nowadays to get legislation passed because of this thing called the filibuster. Basically, the filibuster says that unless 60 of our senators agree on something, somebody can institute a filibuster, which traditionally meant you could stand up and talk forever about something and just stall the legislation from getting passed forever. Nowadays, there's a way to block legislation without literally standing up and talking, like for 10 hours. But anyway, it's a way of blocking legislation. So it's going to be a tough battle to get it through the Senate, and we'll have to see what happens, and I will update you as we go through the semester. So there are things in the works to codify this, and most constitutional law scholars think it will eventually get codified to a certain extent. But in the end, because of the current makeup of the Senate, there'll be some regulations on abortion that people who are pro-choice certainly will not like. All right, now we turn to the rights of people in the gay and lesbian and transgender community. And one theme you'll see as I talk about these cases is that the Supreme Court kind of doesn't know what to do when it comes to gay and transgender folks. And what I mean by that is they're kind of inconsistent about what part of the Constitution they're going to look at in a given situation to try to protect the rights of gay people. So what you'll see is sometimes the right to privacy will be the focus. Sometimes the Equal Protection Clause of the 14th Amendment will be the focus. And sometimes it's the Due Process Clause, also in the 14th Amendment. So going way back to 1986, there was a case called Bowers v. Hardwick, which some people can hardly believe was ever on the books from 1986 to 2003. But in any case, there was a couple that were caught by the police, supposedly in the act of having intimate relations. There's some debate in the history of the case about whether or not they were actually caught in the act or not. It's kind of a muddled case history. But in any case, the legal issue that was the focus of that case was whether or not an anti-sodomy statute that only applied to same-sex people was constitutional or not. And if you don't know what an anti-sodomy statute is, it's, well, just like it sounds. It's something that makes sodomy illegal. And I feel like a health teacher defining what sodomy means, but oh well, sodomy is oral or anal sex. And back in 1986, the Supreme Court said that it was okay for a law like this that was on the books that only applied to gay people in this circumstance, that was okay, that there was no violation of the Constitution. And if you look at the language of the case, it's not that they were agreeing that such laws were a good thing. They just couldn't find any protection for this particular couple in the Constitution itself. Thank goodness in 2003, a case with an extremely similar factual background came before the court. And the question that the Supreme Court was analyzing at the time was the Texas homosexual conduct law that criminalized sexual intimacy by same-sex couples, but not identical behavior by different sex couples. And the question was whether or not that violated the 14th Amendment guarantee of equal protection of the laws. And they also talked about due process. So the court also recognized the similarity between this case and the Bowers v. Hardwick case, and specifically pinpointed whether or not the Bowers case should be overruled. And thank goodness the Supreme Court decided yes, the Bowers v. Hardwick case should be overruled, that decision was not a wise one, and that this particular statute violated the due process clause. They did inferentially mention equal protection, but they were really hanging their hat on the due process clause, which is a very generic term for fair treatment by the courts. And part of the language of the case said that they should have the full right to engage in this type of conduct without intervention of the government. And a lot of constitutional law experts were a little curious about why they didn't use the right to privacy language here, but they didn't. They mostly talked about due process and talked a little bit about equal protection. The next landmark case in the area of gay rights is the Obergefell v. Hodges case, and that is the landmark civil rights case where same-sex couples were found to have the fundamental right to marry, and that right was protected by both the equal protection and due process clauses of the 14th Amendment to the United States Constitution. Most people agreed that it was just a matter of time before this particular right was going to be established by the Supreme Court, because many states, like Massachusetts, had had this right bestowed upon its state citizens by their own state Supreme Courts for quite some time. Massachusetts established this right back in 2003, and the Obergefell case borrowed very heavily in its language from the 2003 Massachusetts decision. And a lot of people have wondered, well, what's the big deal about the right to marriage, and wouldn't a civil union suffice as the same exact thing? Well, along with the fact that, only granting gay folks the right to have a civil union or something like that would be, some would say, affording gay people a second-class status. It also would make it so that certain rights that you have when you're a married couple, gay folks wouldn't have. If you look at some of the footnotes in both the Massachusetts case and the Obergefell case, you will see that there are about 1,500 rights when you're talking about federal benefits, inheritance rights, health options, so on and so forth, that are only available to married couples. So that was settled in 2015. A lot of people are fearful about what might happen with this right and that this case could be overturned because of some of the things that Clarence Thomas said in his concurring opinion to the Dobbs v. Jackson case. If that interested you, you could just Google, Clarence Thomas's dissent. Another landmark case when it comes to the rights of gay people happened in 2018. And you might have heard of the famous Masterpiece Cake Shop case. And this was the case where the Supreme Court had to decide whether or not a bakery owner violated the Constitution when he refused to create this custom-made cake. When you get married, you pick a place based on reviews or whatever, and you go in and design your cake, and you will have the cake shop, under contract, and you'll pay them to make your wedding cake. So he was asked by a gay couple to do that, and because of this particular cake shop owner's religious beliefs, he argued under the First Amendment that, no, I shouldn't be forced to do this for them. I'm not refusing to serve them entirely if they want to walk in and buy one of these pre-made cakes out of the, little fridge I have out front of pre-made things, that's fine. But they're asking me to create a custom cake for them, and my First Amendment beliefs, my religious beliefs, prohibit me from doing that. And some people were surprised when the Supreme Court sided with the baker. In other words, the Supreme Court said that the baker did not have to bake this custom cake for the gay couple. And essentially what they said is, well, one thing we're looking at is the battle between First Amendment freedom of religion and an alleged discrimination against a gay couple. So an alleged violation of equal protection and due process. And they said when doing that balancing act, since the couple had other cake shops they could go to, and since the baker wasn't outright refusing them service, they sided with the baker. Fortunately, a couple years later, there was a case that was more of a victory for the LGBTQ community, and that was the Harris Funeral Homes case. And you might have heard about that case in the news, where a transgender individual who worked at a funeral home, who used to present as a male and started presenting as a female, was fired because of doing so, and brought a case up before the Supreme Court of the United States alleging discrimination. And the case was brought on her behalf by the EEOC, which is the Equal Opportunity Commission of her state. And the Supreme Court ruled that due to the equal protection, again, and due process guarantees of the Constitution, you can't fire somebody for being transgender. A year later, the Masterpiece Cake Shop case was back up in front of the courts again, and this time it was a slightly different situation, and the cake shop owner, the same one, was refusing to bake a cake for somebody who was transgender, and it was part of a celebration for this transgender individual. And in this case, they sided against the cake shop owner. So in the end, the themes that emerge, as you can tell, there's not a purely consistent trend when it comes to the Supreme Court analyzing what rights gay folks have or don't have. I don't see, Lawrence v. Texas being overruled anytime soon. I don't see a world where, only gay folks could be prosecuted under anti-sodomy laws, although nothing would surprise me. But because of recent events, I am a little bit worried about gay marriage, and the transgender community is sort of curious also about where their rights stand. So in any case, the Supreme Court looks to different places. They will inferentially, in cases, refer to the right to privacy, but they will mostly be talking about equal protection and due process. There are other rights that pertain to the rights of women that I won't have the time to get into too much detail about because this video is already getting too long. But one thing I did want you to know about is the basic levels of scrutiny, the 3 different tests that the Supreme Court will look at when it's deciding whether or not a certain law that treats somebody differently just because they're a member of a certain group, whether or not that violates the Constitution. So I'm going to show you this and then go back. There are 3 tiers of equal protection scrutiny in the Constitution. So strict scrutiny is applied to laws that would discriminate against somebody based on race, national origin, alien status, or anything like that. So basically racist laws, the court's going to put under a microscope. The laws we're going to talk about in a minute that talk about treating somebody different because of gender, they're going to be given intermediate scrutiny. The note there you see about based on gender or illegitimacy. Illegitimacy refers to people who were born to parents who are not married, and we don't see too many laws that are based on that designation, so we won't be talking about that. And then our catch-all group is rational basis. So the court's basically just going to ask if a law is rational if it's any other group other than, laws that are racist or sexist, basically. So going back to these other important cases, one of them is Reed versus Reed. This is based on Reed versus Reed, an old 1971 law that treated males better than females when it came to the Idaho probate code. So what that means is probate codes are things different states have that pertain to how somebody's estate and property and real estate and belongings get split up after the person dies. A person's will designate, who a person gives all their property to, and the probate code of a state will spell out the details about how you're supposed to follow everything that's in the will. And so the Idaho probate code preferred males to females when you're appointing who's going to be the administrator of an estate. And an administrator of an estate is the family member named in the will that's supposed to be your go-to person, sort of the CEO of taking care of everything that's going through the courts. So Reed versus Reed struck down this law going way back to the early 70s in Idaho and said that it violated the Equal Protection Clause of the Constitution. So what we'll see is, unlike gay folks, when the Supreme Court is talking about females or laws that treat you differently just because you're female, they're going to be more consistent when it doesn't have to do with reproductive health and it has to do with different situations. They're going to look at the Equal Protection Clause of the 14th Amendment. A couple of years later, in 1976, the Supreme Court was pretty consistent in striking down laws that treated males and females differently when there was a drinking age in Oklahoma that prohibited the sale of non-intoxicating 3.2% beer to males under the age of 21 and to females under the age of 18. So Curtis Craig, who is a male, then between the ages of 18 and 21, and Carol Whitner, a licensed vendor, challenges the law as discriminatory. So in other words, you can't have different drinking ages for males and females. And turning to probably the most well-known case in this area outside of reproductive health is the VMI case, which is formally known as the U.S. versus Virginia case. Now, as a little bit of background, there's a military school in Virginia called VMI, and they're a very prestigious educational institution. If you're somebody who has VMI on your resume, that's really, really a good thing. It's not as impressive as having Harvard, but it's a very prestigious institution to have on your resume. And back when this case was decided in 1996, they had a really long tradition as being Virginia's only exclusively male public undergraduate higher-leaning institution. So that's one of the key things. Remember the state action requirement. This was a public institution. If it was a private institution, only allowing males would have been fine. This was a public institution. And because it only admitted males, the United States brought suit against Virginia and VMI, saying that the male-only admissions policy was unconstitutional because it violated the Equal Protection Clause. And part of what was threaded through the case is that, it's such a prestigious institution and gives somebody such a once-in-a-lifetime opportunity that denying females admission was violating their civil rights. So when some lawsuits were filed in the lower courts, before it got up to the Supreme Court of the United States, VMI tried to create a Virginia Women's Institute for Leadership as a parallel program. So that was part of the case also, because the United States still brought the case up before the Supreme Court, basically saying that this parallel program wasn't good enough because it didn't have the same prestige and was pared down, and it wasn't substantively comparable. So the question became, by the time it got before the Supreme Court of the U.S., was, does Virginia's creation of a women's-only academy satisfy the 14th Amendment's Equal Protection Clause? And the Supreme Court said no, in a 7-1 decision, that the male-only admissions policy was unconstitutional, that there was no exceedingly persuasive justification for the gender-biased admissions policy. It wasn't made for any sort of purpose, this policy, that was important enough for the Supreme Court to consider it, worthy of having the males-only policy. So with the cases that are pertaining to gender, you'll almost always see equal protection as the main focus. We won't get time to look into some other important laws, but there are some you can look up if this topic interests you. Surprisingly, the Equal Rights Amendment, an amendment that would have language to the effect of, if you discriminate based upon gender or sex, that's unconstitutional. That is still not part of our Constitution yet. So you might have heard of it getting passed by certain states, and it was drafted, but it hasn't been ratified by all the states and added onto the Constitution. Another important thing for women's rights is Title IX, which offers equal funding for women when it comes to education. Title VII of the Civil Rights Act is also important, although people always think Title VII just applies on the basis of race. There's important language there too when it comes to gender. along with some lesser known laws that are important that you can look at if this is a topic of interest for you. As far as takeaways, one part of your discussion board this week will ask you about our own classroom constitution to establish rules for free and civil discourse of the matters we'll be discussing. But I'll also ask you about your takeaways from Dobbs v. Jackson. Historians, scholars, political scientists, journalists, there's all been a variety of responses. Most people do not favor the overruling of Roe v. Wade. So you'll see a variety of different perspectives. So you'll have a chance to share your takeaway and any questions in this week's discussion board, because we've covered a lot of complicated stuff. And if this were an in-person class, we would have had, about 7 or 8 hours of classroom instruction to go along with it to answer questions. So please feel free to post your answers there. And then you'll see in the weekly folder your things to do before 7:24, reading handouts, going over the cases a little bit more carefully, looking at the week 2 test, looking at your discussion board and reply, and so on. So as always, reach out with any questions. Remember to come to office hours if you need extra help. A lot of times I'll get emails asking for help after I've gone to bed on Sunday night when people are finishing their tests at the last minute, and it's too late for me to help you then. So just plan ahead, and I do, make appointments and meet with people on WebEx outside of office hours too. You just need to shoot me an email and let me know when is a good time. All right? So good luck. Let me know if you have questions.